Okay, we are live. And Andy, to answer your question, yes, you can. At the bottom of your screen, you'll see a row of icons, starting with a microphone, a little camera, CC. Yep. So you'll see that square with the arrow pointing upward.
Yep.
Click on that first, and then you click on the screen you'd like to share, and voila.
All right, let's do it. So can you all see that?
Yes.
Okay.
But before you start, I wanted to welcome you, Andrea and Nick. Thank you so much for joining us today. We really appreciate it. The opportunity to learn about directors and officers insurance claims doesn't come up very often, so I'm very interested to hear what you have to say. And I understand if there's enough time, you will perhaps touch on the new lender guidelines. But with that, thank you for coming, and I hand it over to you two.
All right. Sorry, I forgot my mouse.
Thank you guys for having us today, and I guess good morning.
Good morning.
So we're going to talk today, briefly about at the end we'd like to touch on the lender guidelines, like Paul had said, and we're going to start off with this directors and officers insurance claim presentation. The primary reason for it is that it's this insurance stuff gets a little confusing. The different policies, the way they work, and really the importance of notice and claim reporting and the different interests that need to be balanced as you go through claim reporting. I'm sure some of you have experienced this, maybe some of you have not. But the world of common interest development, association, litigation, claims, it's a world that, because of the prevailing party attorney fee provisions that are in the CC&Rs and also the Davis-Sterling Act, we have more and more claims being brought. We have specifically, some of you may be familiar with a handful of firms here in the state that are specializing in bringing member claims against associations. And our office does a lot of work defending associations, their volunteer directors and managers in these kind of claims. So we just thought this would be a good time to revisit how claims are processed and just kind of give some background on our experiences and what you as managers should be looking at as you kind of wade through member claims.
First one here.
First one is you.
Okay, so with that, we want to be able to give you guys some sort of practice pointers going away, really, because most of these claims are going to pass across your desk really long before they ever get to probably the board or to the association's counsel's desk. So, and part of the challenge is sort of identifying and making decisions about when a claim should be made and when it shouldn't. So we're going to talk a little bit about that later. But just a couple sort of general topics or points we want to cover. CID insurance. So just for anybody on the video conference here who may not be really familiar with the insurance portions of associations and how they are managed. Here on the slide are basically the types of insurance that most associations will carry, right? So you have to carry the casualty policy. There's going to be some property that they have to insure, and that's going to be through that first party casualty policy or property coverage. Most have some type of workers' compensation, maybe a rider on the CGL policy. That everybody has to have fidelity crime insurance now in certain amounts statutorily required. Most associations have been carrying that type of coverage for a long time anyway. And then there may be other types.
Andy?
Yeah.
I'm sorry to interrupt. Are you going through a PowerPoint? Because right now we don't see the actual whatever slide that you're currently on.
Oh, really? Yeah. We see it. Hang on, let me see if I can fix it.
What you probably want to do is stop sharing
Okay.
and then reshare and pick the screen where the actual,
Yeah, that's how I did it before. Hang on.
okay.
Uh,
It did progress to the new screen, to the new slide.
oh, it did?
Yeah, but it's the small version. It's not the, we're seeing your,
Let's see if this works. No, that's going to bring an
no,
email up.
what I would do is unshare and then start sharing again and
Yeah,
click
I'm
on
trying
the,
to go.
okay.
Let me see. Hang on a second. Let me try to get to the unshare screen. Stop presenting. And then go back here. So do I click on your entire screen or a window? Probably entire.
Well, if you do the entire screen, then you can move things around and get us what we want. Either way will work, but if you do a particular window, you have to make sure it's the actual presentation and not the PowerPoint software.
Okay, so let's see if this works. Does
There you
that
go.
work?
Perfect.
Okay. All right. Thank you.
Thanks.
You're welcome.
I'm a little bit tech challenged, but I'm figuring it out. Okay, so in addition to the fidelity crime insurance, there may be other types of insurance like earthquake, flood, etc. So that's casualty is the primary one for property coverage, right? Then you have the CGL policy, commercial general liability, and the directors and officers liability. Most of what we're going to talk about today really has to do with directors and officers liability. And so that's kind of where we're going to focus today, because of course, in the time we have, we can't really cover everything with respect to these other coverages. Okay, so D&O and CGL, who's insured? So here's basically who's going to be insured under these policies. So the association, obviously, primarily. Directors and officers, that can include current directors and also former directors, because sometimes claims arise resulting from decisions that are made by directors who are no longer on the board or who recently went off the board. Committee members and other volunteers, for example, architectural committee members, enforcement committee members, the inspector of elections, if that person is a volunteer member of the community. Employees might be, if there's on-site management that's an employee, or maintenance, persons, janitorial persons, landscaping. If they're actual employees of the association, they may also be covered. And then, of course, management is typically going to be covered under an additional insured endorsement to these two types of policies. All right.
So the key to thinking about these different policies is that, as Andy was saying, the casualty policy, that's going to be insuring like something like the common area. There's some sort of event. Lightning strikes the common area roof, or there's a fire in the common area, or something like that. That's just what we call a first party claim. And you're going to go and tender that, and it gets taken care of to repair that association property. D&O and CGL are third parties claims. So when like a member brings a claim. And on the D&O, your D&O policy really just covers economic loss. So we're looking at some sort of wrongful act. You violated the CC&Rs. You were arbitrarily enforcing. You breached a fiduciary duty. You just approved something that was in violation of the CC&Rs. Whatever it might be, something like that. It's going to cover resulting economic damage from that wrongful act. And it's going to, sometimes I would say more importantly, cover the cost of the defense. So when the claim's made from the date it was tendered on, the lawyer is going to be paid subject to deductibles, paid by the D&O carrier. CGL is different. The commercial general liability policy, that's going to be property damage and personal injury. So the member's walking down the path, trips and falls on the common area path and hits their head, they have a personal injury. Or there was a failure to maintain pipes and it resulted in water damage that damaged the inside of a unit. That could be another, there's a myriad of ways that this can come up. but it too will cover the cost of the defense to that claim, but the damages arising from the claim are covered by the different policies. So that doesn't mean that they're completely separate, but what it does mean is that there could be overlap, or it could be separate depending on how the claim is made. So as you see here, you can have a breach of governing documents that trigger both policies, the D&O policy or the CGL policy. But they come up in I'm sure you guys have seen these things over the years. You can have breach of the governing documents, improper use of association funds, things that come off as kind of like an error or alleged error or omission in judgment of the board or management. That's going to tend to trigger your D&O claim because there's some sort of wrongful act that they're alleging in violation of either a legal duty or a duty under the CC&Rs. The CGL can be the same, but it also gets into issues of just general premises liability. And so those are the things you're going to want to be thinking about, because it's not as simple as, oh, do we have insurance? It's which policy is going to cover what. And there's a reason for that. If I get to the next slide, is because the policies, if you think about it, they're contracts and they have different terms. A D&O policy is a claims made, claims reported policy. That means that the claim is typically going to be defined within that insuring agreement, and it triggers when the claim has to be reported for there to be coverage. The CGL policy is an occurrence policy. So it doesn't really, it's not so much as when the action was filed or when the letter was sent, or it's really about just when did the event that gives rise to insurance, the fall that occurred that we were talking about earlier, or some violation. When that occurred, that's going to be when that particular policy clicks in. And the reason this is important is really due to my next slide, and this is really the guts of the presentation. A claims made, claims reported policy requires that when there's a claim, that it be reported during that year, or you can lose your coverage. And one of the reasons why we think this is so important for managers is, one, out of self-interest, right? You are typically an insured under that association's policy. And two, what typically happens in our experience is, say a letter, or Lord knows the amount of emails you guys probably deal with. Some email comes from, owner in unit 123, and it says, like, you didn't approve my architectural change, or you're treating me different than this person or that. And then management sends it to the board, says, this occurred either in between meetings, or here's something we need to discuss at our next board meeting. And there ends up being an immediate response, understandably, that wait a second, this isn't true. Oh, this person's making this up, or we have defenses to this, or here's the story. And what the purpose of this presentation, and what I hope you guys take from what we talk about today, is that actually the first step is to stop and say, wait, is this a claim? And does this claim need to be reported? And if so, when? Because a claim is really, again, a defined term in that insuring agreement that's going to say a written demand for monetary or non-monetary relief. If you sit back and think about that, that's a really broad definition. And the reporting requirement is when you have a claim combined with a wrongful act, that means it's a reportable claim. So when you have the email that says, I was entitled to, this modification, this architectural change, and you guys wrongfully denied it because the CC&Rs allow it, right there in that email, you could have a claim. And getting out of the habit of thinking a claim has to be something to the DFEH or a lawsuit or a demand for mediation or arbitration or all these different formalities, but getting into, wait a second, these emails and these letters and that neighbor or that member who constantly writes us, those paper trails, staying on top of them, those are key, because if you don't report that claim during that claim period, during that year, when that insurance policy is in effect, you might end up not having coverage if it does ultimately result in a lawsuit that's filed outside of that year. So we can go back over that. I'm giving you a lot of information, but if you go to the next, yeah, okay.
Go back to it. Okay.
Yeah, the premiums and underwriting. So the pushback that you'll often get is that when you go to the board, or even you might be thinking, oh, wait a second, should we report this? Because if we report it, our premiums are going to go up. Lord knows, I'm sure you guys have experienced that, insurance costs, like everything, have gone up a lot over the last decade. And the concern being kind of like with an automotive policy or your casualty policy, that, hey, if we make a claim, the premiums are going to go up. That could be true, but typically, unless you have a lot of claims with these D&O insurers, in a single year, the premiums really only go up if you end up starting to have a loss run, meaning they assign a lawyer, the lawyer begins billing on it, or there's a payment made outside of the deductible to the complaining party. Unless that happens, you're typically not going to get your premiums going up. And if you really think about it, well, if my premiums are going to go up because there was a loss run, that means you probably needed the insurance. And you're always having to weigh, the fiduciary obligation to protect that insurance policy, because that's what it's there for, right? Even the most ridiculous claims, which we defend daily in our associations, they cost money, right? Lawyers are expensive, and it's really easy to file a lawsuit. It's very cheap. It's a lot more expensive to get out of them. So you're constantly weighing those two interests. Is this a claim, and do we need to report it right now? And one of the things we'll get to in the tips is to be aware of when those insurance policies expire or renew every year, because that's a date that you're going to want to have on your calendar, particularly when you're in these prolonged disputes. It's a noise dispute that's been going on for months, or an architectural dispute that's been going on for months. As the days click by and more writing is generated on these claims, you're going to want to know right off the bat for your board and for you, if for nothing else, because managers get named in these cases as well, to say, okay, when does this renew? So if you get, again, to the next slide, it's just getting to, you have to give, there's always this contractual obligation in the insuring agreement on a D&O policy to give notice of a claim made during that policy period. And then you go through this checklist. Have they said there's a wrongful act? Do they say that there's been damages? Because at that point, you're going to want to start talking to your board about, do we need to report this, and do we need to talk to legal counsel? Yep.
Okay. So this assumes, okay, so we've made the claim, right? We've made the decision that we need to notify the insurance companies, and the D&O carrier has now concluded that there's coverage for the claim. They're probably going to appoint defense counsel at that point. So who decides? Typically, it's going to be I think this was your slide actually. Typically, it's going to be the insurance company's decision about who gets appointed as defense counsel. Most insurance companies will have, a panel or a list of attorneys that they've already vetted, that they've already approved, and they'll appoint one of them. And all of you have been doing this for any period of time, probably has dealt with some attorney who's been appointed by the insurance company. And you know that in some cases, some of them are very good, and then other cases, some of them are not very good. And it's pretty infrequent, I think, that you can find somebody who's going to be, pretty well versed in HOA law, right? So there are some, Nick being one of them, who gets appointed by insurance companies to handle cases, and he's been doing HOA law for what, 10 years, 12 years, I don't know, something like that. So he's well versed, but it's pretty rare that you find somebody who has that level of expertise, because what we do is just so specialized, and our industry is not that big. So during the period of time, what I want to talk about, this is one of the sort of practice pointers for all of you. What do you do during the period of time that the insurance company has been notified of the potential claim, wrongful act, whatever, between that point and the time that they actually pick up coverage and appoint defense counsel? During that period of time, there may be deadlines that are pending. There may be things that need to be done to protect the association's interests and exposure to liability. So it's really a good idea for you to notify the association's corporate lawyer, their general counsel, what's going on. This is especially true if there's some sort of lawsuit, or, like Nick said, a claim to the Department of Fair Employment and Housing. And you're going to usually know that when that happens, and there's going to be some actual hard deadline for making a response, right? As opposed to a demand letter that just demands some response within some period of time. A good example would be a request for resolution for mediation, for example. So the statute gives the association 30 days to respond to that request. And if they don't respond by accepting it, then it's deemed denied, right? So there are these statutory deadlines that we need to meet. And sometimes the insurance company doesn't come back right away with a position on coverage. And so steps need to be taken during that period of time to protect the interests of the corporation and any of the other parties who've been named in the claim, directors, management, whoever. So get in touch with counsel. It may be that nothing needs to be done. I mean, most of the time, general counsel will sort of say, well, let's take a wait and see approach, and then be in touch and basically put the insurance company on notice that you need to report back within some period of time, so that steps can be taken to preserve the rights. And if the association's attorney has to do something in the interim, that they'll expect to be reimbursed for the cost of legal fees during that period of time. It's pretty unusual for the insurance company to reimburse the association for legal fees incurred by a lawyer that they haven't appointed. So most of the time, the lawyers that do what I do, we try to minimize the amount of involvement so that the association is not coming out of pocket on the expense, on legal expenses that would otherwise be covered by the insurance company. So keep that in mind. And that's if the claim ultimately is insured, right? If you get a coverage determination where where it's not insured, then we're going to talk about that on the next slide. Do you want to talk about the reservation of rights?
I can talk about that. Before I get there too, is as you're going through this, one of the other things on this slide is what do you do during that coverage determination? You should also know, and your board should know, that typically the duty to reimburse the association or begin to burn on that policy, both on the deductible or actual out-of-pocket fees for the insurer, is that duty is triggered by the date the claim is tendered. So again, as you're going through these long, as we know, these association disputes can last months. I mean, some of them last for years before they get into litigation. If you've tendered it early and it ultimately is determined by even 9 months later by the insurer, oh wait, we have to pick up that claim. The date isn't from the date that they decide to pick up the claim. The date where the reimbursement begins is the date when it's tendered. So as you're going through that, should we tender it now? Particularly if corporate counsel is really involved and is running up, they're doing a lot of work and there's a lot of billing going on, and their board is worried, well, we don't want to tender it because of our premiums. Well, the balance to that is, yeah, but you might want to tender it because your deductible is not being eaten into because you haven't tendered it yet. And you might even be outside your deductible at this point. And now you're paying out-of-pocket fees to the corporate counsel when it really should be on that insurer. Or conversely, as the more time that goes by when the insurer is sitting on it, you're keeping track of those bills that you can then submit to the insurer later and say, well, we tendered on this date 6 months ago. We'd like to be reimbursed for all of those fees. So that's just another point I wanted to make while the coverage determination is going on. Now, as a reservation of rights, this is kind of more complicated, but the simple way to think about it is we were talking about that defense duty earlier, and every insuring contract has two primary duties, whether it's your car, your automotive insurance policy, an association's D&O policy, it's commercial general liability policy, or maybe your own homeowner's policy for your home. Those two duties are, one, to indemnify you for damage. So, I accidentally hit someone with my car, that person had injuries, they've sued me, it turns out, yep, I was liable. You're going to pay them for all their pain and suffering, their medical bills. The insurer has that duty potentially to pay for those damages. But the other duty is to defend you in that action. And so that defense duty, what many of these policies will do is say, we agree to defend. Because the duty to defend is broader than the duty to indemnify. We're going to defend you, but subject to our reservation of rights. Just because we're defending you doesn't mean we have to pay the damages that might come from this lawsuit. And so when that happens, you're going to want to be able to speak to your corporate counsel so they can explain to the board and maybe even your management company those differences, because just because you have an insured doesn't mean you don't have risk if the case goes south. And then the second part is, if they're, not to get too into the weeds beyond what we've already done, but there's a thing in California called Kumis Counsel. And Kumis Counsel means that if that reservation of rights, if the insurance defense counsel can eliminate claims that are covered, that triggered the policy. So let's say there's 8 causes of action and 3 of them triggered the defense duty. If the defense counsel can get rid of those 3 claims, thereby the association loses its defense, corporate counsel can ask that Kumis Counsel be appointed. And that's a separate lawyer who's going to either litigate it or oversee the litigation to prevent that from happening without the consent or the direction of the association.
So basically a lawyer to babysit the other lawyer.
That's the simplest way of putting it. Yes.
Yeah.
A lawyer to babysit the other.
Yeah.
And look out for the management company.
Yeah, to look out for the insured
associations.
interests, right?
Yeah.
And it's not super common. I mean, it doesn't happen on most cases, but in some cases it's necessary, which is another reason why having corporate counsel involved is good, because they can identify those issues. So if you get a coverage letter where they've picked up coverage under a reservation of rights, make sure you send a copy of that letter to corporate counsel so that they can look at it and can sort of advise initially what needs to happen, if anything. The SIRs, that when Nick was referring to deductibles under these policies, it's referred to as a self-insured retention. Essentially, we're just saying deductible. They're slightly different for purposes of this presentation. It's the deductible, right? And it's just the amount that the association has to incur in the expenses before the insurance company is obligated. Their obligation to pay kicks in, essentially, right?
And I'll say on that point, we were talking about insurance becoming more expensive. 10, 15 years ago, and I'm sure some of you have had this experience, the deductibles and SIRs on, say, your typical D&O policy could be like $1,000 or $2,000 and maybe $5,000. Those have gone up significantly. They're like $10,000, $15,000, $25,000, even $50,000 now. And so that's what I mean when you're getting in these prolonged disputes. You're going to really want to think, okay, do we tender? Because if you do, and even again, they don't pick up the claim right away, but they later do, you can argue that all those fees that you paid to your corporate counsel should go towards satisfying that deductible.
Yeah. Okay, so claim is made. We talked about what happens when it's insured, and then just briefly, if it's not insured, and not all claims will be insured, but if it's not, then ideally you've already contacted corporate counsel. And then they can advise how to proceed. If it's not covered, the association may need to pay out of pocket to have a lawyer involved, or they may decide that they don't need a lawyer involved at all. It just depends on what the type of claim is and whether or not the board thinks it can be resolved without the involvement of lawyers. Sometimes, if the claim is not covered, corporate counsel may say, well, we think this is a claim that typically would be covered, and we will recommend that coverage counsel be retained to, basically to evaluate whether the insurance company has made the wrong decision about coverage. And coverage counsel can be expensive, but definitely worth the money paid if they can trigger coverage, especially if there's something like a lawsuit or some type of claim that's almost certainly going to result in pretty extensive legal fees to defend the defendants in that case. And those are the sorts of fees that you would definitely want the insurance company to be paying for. So having coverage counsel get involved, and by coverage counsel, I mean basically an attorney who is an expert or specializes in insurance coverage claims. So they'll take it and they'll look at the insuring agreements, look at the claim, look at the letter of declination, and basically make a determination of whether or not the insurance company has made the right decision or not, or whether there's a basis for the insured to push back on the declination of coverage. And then
the term you'll hear them talk about is whether the insurance company is engaged in bad faith.
Yeah.
In this determination.
And so, and it may be that there isn't. Maybe the insurance company made the right decision, or sometimes maybe there's an ability to push back in some way. Maybe it's in a gray area, but maybe you can trigger some type of coverage. In some cases, that's going to make sense to go down that path and spend that money. In other cases, it's not going to make sense, but making sure that the board is aware that there's an option to push back and to retain coverage counsel to evaluate it and make that decision is sometimes helpful to know. Okay, so some practice pointers here. So obviously have the right insurance. So having the right types of insurance, and certainly directors and officers coverage with respect to the amounts that are required is necessary for the volunteer directors to benefit from the statutory immunity provided in Civil Code 5800. So, and making sure that the D&O policy is broad enough to cover all of those parties we talked about earlier, the association, current and former directors, management, employees, if the association has them, is necessary. And of course, I know you guys use qualified and experienced HOA insurance brokers to place the insurance, and that's obviously pretty critical and pretty key. But if you have an association that's used to working with some other agent or broker, and maybe that they don't have that requisite experience, try to convince them to go someplace else, because we have seen, I mean, I'm working with an association right now that doesn't even have D&O coverage. They've never had it. They're professionally managed. Why they don't have it is anybody's guess. But their insurance agent didn't recommend it, didn't tell them they needed it. The manager didn't recommend it, didn't tell them they needed it. And so now they obviously have a claim, and it's not covered. So it's hopefully can be resolved easily, but if not, and it turns into some sort of litigation or something, and they are working to get D&O now, but it's not going to cover this claim. So if they have to pay out of pocket, both like on the defense costs and potentially the indemnity, if there's some sort of settlement or ultimately a judgment, then they're going to pay dearly for not having that insurance.
And I'll just add to that is, if for nothing else, you're on self-preservation. I mean, your company and you individually, within the scope of your performing your duties as a manager, you would be the additional insured on that policy. So making sure, A, that they have the right policy, but then also the quality of the policy, speaking with the broker and your partners that you work with, you can actually be looking at it from your perspective. So that's just a little bit I'd add there. So finally, be vigilant. It's not a panic button. It's just in the era of emails and letters and minutes and all the different things that we generate a paper trail, people are so litigious, and half the time they don't even know what they're saying, but they put it in there, and the policy can flip over, you change providers, and then the lawsuit comes. And I've had cases, a handful of cases in the past where the D&O carrier picks up the coverage, and then you're in mediation or litigation, and a document gets produced in discovery that an email or something that shows that, you know, a claim was made prior to that policy period, and now all of a sudden the insurer's threatening to pull coverage and leave people exposed. And that's really the ultimate problem with the D&O policy, right?
And they would be pulling coverage because
of a failure to report the claim during the reporting period. So you can end up having, unlike a CGL claim, where it's bodily injury or property damage, in these D&O claims, you can have a claim that meets the four corners of the insuring agreement, but you don't get coverage because the one thing it didn't do, it wasn't reported during that policy period. So again, if you get those emails, you get those writings, something's brewing, you reach out to your corporate counsel, you know, you look at when does our insurance renew? That's going to tell you, hey, how much time do we have to deliberate on this? Do we need to report it? Should we start to? And there's just a host of factors. And really, the boards, again, for the most part, they're going to be like responding like most people would. Wait, there's no truth to this. This is ridiculous. Or did we mess something up? Or whatever it might be. They're going to look at the substance. It's important for the management to be the ones that look at procedural. Okay, before we even get there, are we handling this right? Are we claim handling it correctly? And managers, you know, you guys have a lot of different hats you wear, a lot of responsibilities. One of the main things to do is just, hey, I think we should talk to corporate counsel about this, get them to look at it, and, you know, go through our checklist and make sure that I's are dotted, T's are crossed before we charge into the substance of the dispute to protect those policies, because you really never know exactly where these things are going to
go. So I just wanted to mention a couple things about making the actual claim. So we talked a lot about what does the policy say and what types of claims are covered and what are sort of the things to look for, like how does this stuff come up? There's not an expectation that management be experts on that. We're not suggesting that you have to read the insurance contract or do the analysis yourself or anything like that. That's not really what we're talking about here. You really should be leaning on the insurance broker to help just, you know, determine, like, is this going to be something that should be reported, and to which insurance policies should it be reported. You should not be making that decision. In fact, we don't even make that decision when we help our corporate clients tender claims and notice of those claims. We send it to the insurance agent or broker, and we tell them, you know, basically in broad language, report this to any applicable insurance policies that may provide coverage for the underlying claims. We don't do anything other than that, and then provide them with the writings, with the emails, the letters, whatever, so that they can then look at it and make a determination of which policies need to be notified, which insurance companies need to be notified. So the reason why it's helpful to sort of know, you know, who's covered under the policy, what types of things can give rise to claims under these policies, is just for you to sort of have it on your radar, so that when these issues come up, when you get that, you know, letter from the owner, when somebody, you know, doesn't threaten legal action, but, you know, has a subtle email to you that says basically you better do this or else, sort of thing, then you kind of know, well, that might be a claim, and should we be reporting it? Ultimately, it's the board's decision about whether a claim should be reported. And I think that, and maybe Nick, you want to weigh in on this too, is the most complicated part, or the most challenging part with boards, is because they never want to make, not never, I shouldn't say that. They often don't want to make the claim because they think their insurance premiums are going to go up, and probably this can be dealt with, you know, without having to get the insurance company involved and whatnot. But and that's fine if they want to make that decision, but we need to make sure they're making that decision eyes wide open, right? Here are the potential ramifications if you don't make the claim, if you don't notify the carrier, you know, at the earliest possible time that you can, and what could happen from that. And so from your point of view and protecting Collins management, you definitely want to make sure that the board understands the ramifications of making a decision not to report a claim, which could mean that later there's not coverage if they do choose to report it, or it means they're paying out of pocket. And they need to understand what the reverberative effects of that decision are. Meaning, if the thing does go sideways, for example, and there is no coverage because of late tender, or they choose not to tender it or whatever, what happens if they have to spend a lot of money on a lawyer? And do they have money to pay for that? And if they don't, do they have to levy a special assessment or increase assessments? And then how are they going to explain to the membership, we have insurance to cover this, but we opted not to make the claim because we didn't want to increase premiums, yet we decided to pay tens of thousands of dollars out of pocket to a lawyer to protect us. So, I mean, that's a hard sort of communication to have with the members. And it's really, really difficult, I think, to predict at the outset of a claim where it's going to go. And again, they can choose not to make the claim, entirely within the board's discretion, but they need to make sure they're doing it, understanding what the benefits are of making the claim and what the disadvantages are of making a claim or not making the claim.
I would just echo that you as managers have issue spotters, and that you can reach out to corporate counsel and brokers to be help problem solve it. And the board ultimately makes that decision. And so, you know, sometimes it's with informed consent to tender or informed denial, but we need to be able to inform them. And that's really the point of the presentation. And thank you guys for listening in. We can take some questions and then also touch on those lender guidelines that Paul had mentioned.
Yeah, and I can send, if it's helpful, Paul, I can shoot this PowerPoint over to you and in a PDF, and you can send it around if it's useful to just have the bullet points, you know, that we talked about. And it also tells you how to reach us, of course, because we have to plug our firm. That's, you know, so you know where to find us. I'm going to stop sharing the screen and then go back to the.
I have a question.
Yeah.
With respect to notifying the broker or agent of a potential claim. So let's say you get an email or a letter, and there's, you know, kind of some soft innuendo about you know, hiring a lawyer or taking further legal action, implying but not being very direct that this may result in some sort of legal action. So we've been where I have in the past been able to reach out to my brokers and just say, hey, there's this potential claim. We don't necessarily want to open a claim, but can you put a note in the file? And they tend to be pretty open to that. And they say, yeah, we'll put a note in the file. And the implication is, and I've been explicitly told this, is that by them noting the file, even though a claim's not opened, if at some point in the future there is a claim, then you would theoretically still have protection because you did give that notification to the broker, even if it didn't go anywhere further than a note in the file. Has your experience found that to be an effective strategy? And the second question would be, would that strategy, does it work better if it's, say, a farmer's agent for a farmer's policy, as opposed to, say, you know, going to Socher, where they may work with any number of underwriters that are not part of the same company?
That's a really good question. Okay, the first one, a note in the file. So I would say that so long as the note is communicated in writing to the insurer, right? So, and that kind of leads into the second question. If it's a farmer's broker, right? That note in the file theoretically is imputed onto farmers. If you're putting a note in the file for Socher, who's its own syndicate, its own broker, and it's not necessarily tied to a D&O carrier or specific underwriter, like, I mean, they sell their products, but they're not Travelers, they're not Great American, they're not CNA, they're not one of the D&O carriers, then it might be a problem. What we do in those cases, though, is kind of, Paul, is like and it's a very astute point, is when that note comes, say, to our office, and it says, because you're right, many of these are gray, right? What we do is first just say, well, look, Collins Management doesn't make the call. and the board doesn't make the call. And really the broker doesn't make the call. The insurer makes the call. So when we tender it, we call it not a tender, we call it a note, which is just a potential claim. And we make sure there's some writing. And that serves two purposes. One, puts the ball in their court, right? If they say, no, it's not a claim, you're covered, and the rate doesn't go up. And the other part of that is, and this is really important, is we have these kind of potential claims that float out there, right? And we have different managers that are handling and different boards, and the memories and the communication lines can change over time, and these claims and disputes can go for a long period of time. And making sure there's some note in that file when there's a renewal, especially if you're going from farmers to travelers, from farmers to Great American, whatever, you want to make sure that there's some disclosure in there so that if that percolates up with a new carrier, they can't say, oh, when you went to get a new insurer, you didn't disclose everything to us, that there was this potential risk. So those notes are really important. And the way, that's exactly when we were saying, issue spotting, and then we problem solve. One of the ways is what you just said, is we don't necessarily give the advice for every single one, tender it. No, we call it either a potential claim or a note in the file, or we frame it some other way. So we're trying to push back on the insurer so they can't have it both ways, but we're protected.
Thank you.
So, Brad, did you have a question? I think it said your hand was up.
Yeah. So an HOA tenders a claim, and the insurance says, "Yep, you've got a claim here." The insurer goes ahead and assigns counsel to the HOA to defend the claim. The issue that I'm running into is that the insurance assigned counsel isn't familiar with the nuances of HOAs and HOA laws. And oftentimes the HOA has to bring in their corporate counsel that's specific to HOAs to help assist the insurance assigned counsel, and then incurs additional fees from their corporate counsel. I guess my question is there a way to help select the insurance assigned counsel? Can we have the insurance assigned counsel be our existing corporate counsel?
So Nick will have lots of opinions on this, so I'm going to jump in first. Having been corporate counsel for 17 years to HOAs, I feel your pain because I am constantly saying, calling these lawyers and nudging them and saying, why are you not doing what you're supposed to be doing? Honestly, this is not just to toot Nick's horn here. The only insurance appointed counsel that I ever worked with that I never had to nudge a single time was Nick. And that's how Nick and I started working together long ago, because he worked at a firm that got a lot of insurance cases and doing directors and officers coverage. And then I was like, well, you're really good at this and you know what you're doing. So then you naturally have to come work with me. So I brought him to, Birding and Weil, and then ultimately we left. But it's really, really difficult because the client should be getting the benefit of the policy, right? They should be getting the benefit of the defense that's owed by the insurance company. So what I would say to that is, and this happens all the time, you're probably going to get a lawyer appointed who doesn't know HOA law. It's, unless you do this all day long, like all of us do, they're probably not going to know all of this stuff. And so there may be little things here and there, like they probably don't know what the Open Meeting Act is. And before the board can make a decision, we have to post notice, and they don't know, well, maybe we have to give 2 days notice for executive session. They just say, hey, let's just jump on a call and let someone approve it. And of course you're thinking, no, we have to post notice. We have to give 2 days notice. We have to hold a meeting. We have to have a quorum, right? And they may not be thinking in those terms. So it's going to probably fall to you to sort of poke them a little bit. But at the same time, if they're really just not doing what they need to be doing to properly represent the association, you should contact corporate counsel and get them involved. But really, corporate counsel's role ought to be figuring out how to make that lawyer do their job. right? And if they're not the right lawyer, pushing back against the insurance company to make sure the insurance company appoints a lawyer who can handle the case. That's easier said than done, but it can happen. The association's entitled to a good defense. They're not entitled to a lawyer who's never going to respond, who doesn't understand the law, who's not going to represent them well. And we, in the past have had success at getting them to either appoint a different lawyer or make that lawyer work harder and so, do what they're supposed to be doing. But it could be a challenge. In my view, the association should not be coming out of pocket to pay for corporate counsel to do anything that is squarely within defense counsel's lane. And if they do, then we need to notify the insurance company. If we have to do your attorney's job for them, then we're going to expect reimbursement on payment, which the insurance company is going to say, no way, we're not going to pay that. So then we have to say, hey, well, you don't have to pay it, but you have to appoint somebody who can do this without having a second lawyer do it. The other thing is Kuma's counsel. You might be able to make a play for that. And Nick talked about that earlier. I don't know, you as being on the other side occasionally, do you have other things to say?
Yeah, I owe Andrea I don't know how much money for that compliment earlier.
Yeah, you can buy me lunch.
But so I think, okay, one, yeah, I mean, I came from a background of being that insurance defense counsel, and frankly, 15 years ago was probably one of the ones that got on with a manager. And managers and directors that do this day to day know right away, like, does this person know what they're doing or what they're talking about or not? Over the years, we're panel counsel here at this firm now for a couple insurers, so we do get appointed and we handle the claims in California for them. Early reporting, we also have relationships because I've just been doing it for years with other ones that were not panel. We make plays all the time, at the tendering level, like, hey, we'll handle this, give it to us, we're going to do it efficiently. We get a lot of success with certain insurers for that. And then there's certain insurers that are just like, nope, we have in-house, we're going to be using our in-house counsel, that's how it goes. And those are the ones that all you can do is push back and, document what happened. And if the fees get so large, there has to be some sort of discussion or there's, threats of additional lawsuits.
But circling back to what you asked, Brad, which was, can you suggest a specific lawyer? Yes, you can. We do that all the time. A couple things to remember. Sometimes the insurance, there are some insurance companies who will never appoint anyone who's not on their panel. Okay, so some will just say no. And unless you're in the game, it's hard to know who those are. But another factor that they look at is, was the attorney that you're asking them to appoint to defend in the claim, the attorney who advised on the underlying dispute that resulted in the claim that was ultimately tendered and covered, right? So let's say I had a corporate client and I advised them on some dispute with a homeowner, which ultimately got them sued. And it wasn't through any fault of anyone. It's just the owner didn't like the decision the board made. The board relied on advice of counsel. They made a decision. Everything happened the way it was supposed to happen. And the owner's mad and they file a lawsuit or something like that. The insurance company may be hesitant to say, appoint our firm to defend the association in that claim because we advised on the underlying claim. And in some cases, there may be, let's say the lawyer maybe didn't do the best job they could have, or maybe there was advice that could have been given to keep them out of a claim or something like that. You never want the lawyer to be in a position of having to cover their own ass rather than defending the client. And so the insurance company, even though that may not be the case at the outset, things change, in months or years later into these claims. And so you're going to want somebody with some fresh eyes looking at it. So sometimes it makes sense not to have, say, the lawyer who's already working with that association to be appointed. And in some cases, the insurance company will just flat out not appoint anybody that's not on their already approved list. But you can make a play and you can say, we've this lawyer handled a claim for us before. We know that they can handle this one. We want you to appoint them and make a play for it and see what they say. The worst they're going to do is say no, right? And then your answer.
So we have relationships with a lot of the firms, even though we're not panel. I mean, just because I've worked on as appointed counsel for just about every insurer in California. the other part I'll say is, yeah, it's not even a screw up. It's just you as a lawyer, you don't ever want to be a witness in your own case, right? If you're thinking, we try cases, we go to courts of appeal. It's not just going to ADRs and whatever. I don't know what I would do if, I was the lawyer who gave the advice, and then they have I'm a witness, and then what? I'm trying the case in front of a jury, and then I swear myself in to ask myself questions. I mean, it doesn't make sense. So in those cases, though, what I will say is the other advantage is, you can tell right off the bat. And I mean, I've been doing it long enough that I know most of the lawyers that do this work in the whole state, and I can direct it. If it's not going to come to me, I make sure my clients get to the lawyer that if it wasn't me, that I want them to handle. And, and the ones that aren't. And I'm happy to have those discussions with the insurance carrier.
So for the associations that you work with, I mean, most of them are going to have some sort of corporate counsel like in place already, right? And so another good reason to call them and say, hey, we have this thing, we're going to tender it. Is this something that we should be, making a play to have you represent it, or just send it off or whatever? I mean, it really just depends on who it is. Like if it's farmers, I don't think I've ever seen farmers appoint anybody other than, their in-house people. But other insurance companies, you may be able to make a play for it, and you can. But ask the question first. Does it make sense to ask for that lawyer to be appointed? And
it's really got to be done at the time of the tender.
Yeah, and do they actually have the requisite experience? Because they could be, like, for example, me, like I'm an HOA lawyer. I've been doing it 17 years, but I'm not going to be appointed to handle litigation because that's not what I do, right? So
although she do a great job.
I help him with it, but I see my role as, keeping you out of litigation and taking food out of my partner's mouth. But ask them, is this the right lawyer for the job? Because it might not be. I mean, they might be well-versed in HOA law, but they might not be competent in handling a litigation or a DFEH claim or something. So just because they're in it doesn't mean they can do it, on that particular issue or that case. So, and before you make the play, to have them appointed anyway.
And last thing I'll say, if nothing else, making the play and making the point, it helps us. I mean, I go to conferences, I visit with insurance companies, I speak at events. We really try and have really made an effort over the last decade to make clear that, a lawyer who does employment defense or, defense.
Premises liability.
Yeah, it does all these different areas. There's different specialties. This thing that we do is pretty complicated. It's corporate law meets real property law meets just the ability to get in front of a board of directors and speak to them to ensure that they know that you know what you're doing. There's skills in all of that, let alone all the, I mean, look at right now. I mean, you want to touch on the lender guidelines stuff and all the different changes you guys have had to deal with the election law in the last 3 years. You're throwing a lawyer into the deep end if, the week before they were doing a slip and fall at a grocery store or something. It's just, they're going to be looking to you guys for legal advice. And so, when you make these talks, it helps us with the discussions we have, because I believe very strongly in it being in the association and the insurer's best interest to have lawyers that are experts in this area litigating these claims.
Right.
We're getting ready to wrap things up. I just had one quick question. I had an experience where Collins Management's insurance, a claim was tendered to them, and it was through Farmers, and they actually gave me the option to use one of their attorneys or to choose any attorney that I wanted, and also had the option of deciding the outcome if we were going to settle, if we're going to go to trial. It was all within our authority. Is that ever an option for an HOA, even if they have to pay a little bit more premium to get that privilege, to get those privileges?
Yeah.
I think it's going to be defined by your insuring agreement, number one. So some, like a property manager, as opposed to a D&O policy, typically, like a for-profit policy, will have selection of counsel clauses, and it's really the language. But I will say, almost all D&O policies, any sort of professional liability, employment practices, EPL, all the different policies that are in that professional liability group will have a consent clause of some form. So even now, not a CGL claim, but a D&O claim, they do require the board to consent to a settlement or what they're doing. But
the consent clause applies to the settlement, not to the choice of counsel.
Not to the choice of counsel, but to the settlement, to your second point, Paul. The kicker to that is that the same insuring agreement will have some version of what they call a hammer clause. So you have a consent clause, but the hammer clause is if on Wednesday they say, the plaintiff says, oh, I'll settle for $5,000. And the board says, we did nothing wrong. There's no way I'm paying Joe in unit 123. He sues us all the time. I'm over him. He's a pain. I'm not giving him a dime. And then they say, the insurer says, okay, you're not going to give us consent. We're going to trial. If we lose at trial, they're paying every dollar of defense costs and indemnity outside of above $5,000 that they get hit with later.
Gotcha.
And if they exercise, that's what they call the hammer clause, because now you're putting skin in the game.
But to get back to your primary question is, can you ever do that if they pay a little more money? I think that's probably a question for the insurance brokers, whether you can get that coverage. I've never seen a policy that gives the association the choice of counsel, although I've seen them appoint counsel that's been requested by the association, even though they don't necessarily have the right under the insuring agreement to appoint counsel. I think the E&O policies, like the one that we have for our firm, the one that you have for your firm, is it's written a little bit differently than the D&O policies that are written for community associations.
Exactly.
Yeah.
All right. Well, thank you so much. I guess, Nick, are you an expert in D&O claims, or were you also involved and were you appointed as counsel for other types of claims, or was D&O your kind of niche?
No, I started off defending doctors and lawyers first 5 years of my career, and I did employment law. And those insurance policies are all in the same group as when you go to these big insurers as D&O for HOA and D&O for profit. And I just started about like 12, 13 years ago at a firm where they just had a pile of HOA D&O claims that they were handling and they needed someone to handle. And I jumped head first, and it's about 90% of what I do.
Okay.
But sometimes coverage is triggered under the CGL policies and they'll appoint counsel as well, but it's much more common under the D&O.
Okay, I just wanted to get a handle on your firm, your young firm, and what expertises you possess. So it's
No one
good to
ever